Go ahead and have the minute brought on now. I'm going to hand this back to you so I don't get mixed up with anything. It's not all completed. Well, Mr. Hendricks, I understand congratulations are in order.
Thank you, Judge.
Baby boy or girl?
Little girl, Charlotte.
Shirley?
Charlotte.
Charlotte, lovely name.
Thank you.
Are you getting much sleep?
I've had more, but we're adjusting, and it's been real great. So.
Joyful, yeah. All right, we are on the record in 15F 158, Commonwealth versus Bradley W. Madden. Mr. Madden is represented by the Honorable Tim Hendricks as a conflict counsel for the Department of Public Advocacy. He is facing 16 charges of intimidating a participant in a legal process. Each and every one of those is a Class D felony. Also, 16 counts of Class A misdemeanor, terroristic threatening in the 3rd degree. Mr. Hendricks, do we want to go forward with this preliminary hearing, or do you want to bind this case to the grand jury?
Judge, we need to have the hearing on this.
All right, thank you very much. We will proceed then, Mr. Hagenbu.
You want them to set a council table?
I think that'd probably be best. All right. Good morning. Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Please be seated.
Will you state your name for the record, please, when you get settled,
Brad Emery,
and your occupation?
Detective, Scottsville Police Department.
And were you doing that back November 21st through the 24th, 25th?
Yes, sir.
And you're not the complaining witness that swore out this complaint, is that correct?
No, sir.
It's my understanding that Officer High did that.
Yes, sir. Officer High and also Chief Jeff Pearson.
And were you present during, are you knowledgeable about this situation?
Yeah, a little bit about it.
Tell us why Mr. Madden was charged.
Mr. Madden made some threats to the Scottsville Police Department's Facebook in reference to, I guess you could say, after his dad was arrested, he was upset about that and was saying that we had the wrong guy and that his father, if his father went to prison, then we would watch our backs for the rest of our life. He also stated that he would be coming for us. And
was that a subsequent threat?
Yes, sir.
Made on a different day?
Yes, sir.
When were these threats made?
It was, I think the first one was on the 21st of November, and just pretty much told us we had the wrong guy and that we better watch our backs. At that time, Chief Jeff Pearson contacted Mr. Madden and advised him to stop the threats, and he said he would. And then the next day, well, maybe it was the 28th, I think he threatened the first day on the 21st. The 22nd he was contacted. The 23rd he made another threat that he was coming for us, and then after that he was arrested for these charges.
Okay, and was he interviewed by Chief Pearson?
He was. On the 24th of November, myself and Chief Pearson went to Macon County and picked him up where he was arrested on the warrant. He was living in Macon County at the time, and Macon County picked him up on our warrant, and then we went to Macon County and picked him up, brought him back here. He was read his Miranda rights on video, and he was questioned about it. Chief Pearson asked him if he did make these threats, and he said yes, he did. And Chief Pearson also asked him if, do you remember me contacting you and telling you to stop? And he said, yes, sir, I did. And he said, and after that, another threat was made. And he said, yes, sir, I did. He said, I woke up the next morning mad. And he said, and there was more, I guess, news, media and stuff going on. And he said he woke up mad the next morning and made another threat to us.
Now, was that interview recorded as well, or just the Miranda rights?
No, it was recorded by body cam.
Okay. And that was one Chief Pearson was wearing?
Yes, sir.
Were you present?
Yes, sir.
Was there any discussion on Madden's part about understanding his rights after they were read to him?
Yes, sir. He said he did understand his rights.
Okay. Was he apologetic?
No, not really. Even to when we dropped him off, we took him to Simpson County Jail, and he was never apologetic about the threats that he made. In the car on the way to Allen County, he even said that it was a promise, not a threat. And that, to me, never did act like that he was sorry for anything that he's done.
Did he make a statement to the effect that, Scottsville, I'm coming for everyone who has said my name and my fam's and my dad's?
That's what he put on the Facebook post.
Now, Scottsville Police Department has a Facebook page.
Yes, sir.
Is that correct?
Yes, sir.
And that's where this was posted?
Yes, sir.
And presumably, I guess, he was in Macon County when he posted it.
I would think, yes, sir.
Okay. And do the Scottsville, do you know how long it was posted on your Facebook page before it was noticed?
I'm unaware, I don't.
And who first noticed it? Do you know that?
I don't.
Did Chief Pearson take these statements on the Facebook page as threats?
Yes, sir.
And did he act as if they were attempts to intimidate the witnesses who may be
Yes, sir.
testifying in his father's case?
Yes, sir.
Were you present when he was warned, Mr. Madden was warned by Chief Pearson to quit?
No, sir, I was not.
And is it true that none of these charges were brought until the 24th after he refused to quit?
Yes, sir. They weren't, the charges weren't pressed until the last threatening message was made.
And if my dad does life, if my dad gets convicted, you'll be doing life watching your back?
Yes, sir, that was.
How is that a threat?
Watching my back, that means somebody's planning on doing harm.
He also made some threats about suing.
Yes, sir.
Those aren't the type of threats that...
No, I wouldn't take, I'm going to be sued for slandering my name as a threat of bodily harm.
All right. How many police officers are in the Scottsville Police Department?
16.
Is that why there's 16 counts?
Yes, sir.
And I'm coming for you.
I mean, he made that threat on the Scottsville Police Department's Facebook, that he's coming for us. So I would think that would be for a whole.
Okay. I think that's all my questions.
Thank you, Mr. Hayford. Mr. Hendricks, you may ask.
Thank you, Judge. May I see the court file,
Oh,
Judge?
sure.
Detective Emery, were you specifically subpoenaed to testify at this proceeding today?
Yes, sir.
As far as you know, was anyone else subpoenaed to testify?
I'm unaware if they were or not. I think Assistant Chief Darren Tabor was subpoenaed, but I don't think he got the subpoena. He's been on vacation for over a week.
Are you the only detective on the force?
No, sir, I'm not.
Do you know if the statements contained in the affidavit are the only statements my client is supposed to have made on that Facebook page?
I'm unaware. I don't.
Do you know if there were any replies to my client through that Facebook page by anyone on the police force?
I'm unaware. His Facebook, along with ours, has a search warrant's been issued to Facebook that will tell all that. As far as us getting that information, we don't have it at this time, but it's in the making.
Okay. So it is possible then that one or more of the officers had reached out to my client through Facebook, and these were replies. That I'm not asking if it happened, I'm asking, as far as you know, is that possible?
It's possible, yeah.
Do you know if there were any private messaging communications between anyone on the police force and my client?
No, sir, I don't.
Who's the officer that's actually been assigned to work this case?
I believe Officer Brooke High.
Brooke High. As far as you know, has my client made any other statements regarding this situation other than the ones included in the affidavit and as part of the interview that you and the chief conducted with him? Aside from those two, any other statements?
He's been incarcerated. No, sir, he hasn't.
Okay. Did he ever give, when you were interviewing him, did he ever give any specific explanation as to what he meant when he made these statements?
No, sir, he did not. He was just upset.
Okay. And I want to be clear. I think this says that on the 21st, he made two statements roughly 4 minutes apart. Is that correct?
I have no idea.
Have you seen the affidavit?
I've seen it wrote out as far as, I guess, on the same piece of paper you're looking at.
Do you not have a copy of that in front of you?
No, sir, I do not.
Judge, may I?
You
have
may.
him review this. It'll take a moment to review the complaint. So then I'm correct in saying, per the affidavit, on the 21st, he is supposed to have made two different statements on Facebook that were approximately made about 4 minutes apart.
Yes, sir.
And it was on that first one where he is supposed to have said something about, like, you will do life watching your back.
Yes, sir.
But of course, in that first statement, he doesn't give any actual specific examples of what that might mean. Correct?
No, sir, he doesn't.
But 4 minutes later, he adds to that an additional statement where he does give examples of things he might do. Correct?
Yes, sir.
And those would be things like sue you for slander, sue you for false arrest, show that this could be a setup by the police force. Would it be illegal for him to do those things as far as you know?
On the first statement that he made, yes, sir, it'd be illegal.
No, sir. My question was, if he believed he had a claim for slander against the police force, would it be illegal for him to bring suit for slander?
Not for slander, no, sir.
What about if it was for a case of false arrest?
No, sir.
If he believed that this was some form of a improper or illegal setup, would it be improper for him to try to prove that?
No, sir.
Does he give any other specific examples of actions that he might take?
No, sir.
If this was a setup by the police force, it's possible, yes, that may mean that some people on the police force committed felonies. For example, if it was tampering.
Object to the speculative nature of the question, Your Honor.
Sustained.
Let me read that past it. What's the statute of limitations in Kentucky on felonies?
There's not one.
So he would have the rest of his life or the rest of any actor's life to prove that he or she committed a felony, correct?
Yes, sir.
And in that second statement, that's what he sets this up with. He is accusing this of being a setup, correct?
In his words, yes, sir.
Which is in line with what is supposed to have been made in the first statement, which is, you've got the wrong guy. Does the department have a written policy for using Facebook or other forms of social media?
Yes, sir, they do.
I have no further questions, Judge.
Thank you, Mr. Hendricks. Any redirect, Mr. Hagenberg?
No, Your Honor.
Thank you. All right. Do we have any other witnesses?
That's all my witnesses, Your Honor.
Thank you. All right, you may step down today.
Thank you, ma'am.
Thank you. All right. Mr. Madden, this is a preliminary hearing. The only purpose is to determine whether there's probable cause to believe that a felony has been committed and you're the person who committed that felony. You are certainly entitled to remain silent. You are not in any way required to testify. However, if you choose to do so with your counsel's advice, you may do so.
I'd advise against it. At this point. Judge.
Right. Does your client want to testify? He certainly does not have to.
I would advise decline testifying at this time.
I'd advise to.
Judge, he does not wish to testify.
Thank you very much, Mr. Hendricks. All right. Is there any argument?
Judge, yes. I think it was fairly clear from the testimony and from the affidavit that while my client, and I'm assuming here that these statements were made, may have made some ambiguous statements that he intended to take some actions against what he believed to be wrongdoing, whether intentional or illegal, or just because they were mistaken. So he may have made some ambiguous statements regarding future actions in response to their actions. But I think it's very clear that he quickly clarified what that issue is. He would seek appropriate remedies under the law. If they're framing him or failing to do what their job is, he's going to see it he's going to see it shown. If there's slander, if they're not going to be careful with what they're saying and have proof of what they're saying, he's going to hit them with a slander charge. Same thing with false arrest charges. I don't think it's appropriate for the Commonwealth to take the position that we are just going to focus on those portions that we want to focus and ignore the things that we want to ignore. These are very statements that seem to work very much on the same process, and wherein my client, who is probably not as articulate as we would like him to be, nonetheless says, look, you got the wrong guy. I don't think you're doing your job right. If you don't do it right, I'm going to take the appropriate actions, such as take you to court. Just that's not intimidating participant in the legal process. That is not illegal. It is perfectly appropriate. Judge, and there is nothing else to this. There's an interview, which doesn't seem to change the context of this. I also am often hesitant or wondering, why is it that the best witnesses weren't called for this? The detective, and it's not the detective's fault, says he's not the most familiar with this. He wasn't privy to everything that happens. This isn't even the case that's been assigned to him. I think it's fairly clear my client hasn't committed a crime. The full context of the conversation is very clear. If he made these statements, the intent was he will hold them accountable under the law. That's why he specifically references these type of court legal actions. There is no other specific statement there which would, I think, permit, certainly not require the court to understand these otherwise less than specific terms in a different context. They are one right after the other, very short succession. There's nothing significantly altering between them, and it does seem to show the same line of thought. He's saying he will expect them to do their job, or he will take appropriate legal action. I think that there's nothing else to be taken from the statements as presented today.
Thank you, Mr. Hendricks. Response, Mr. Higginbooth?
Yes, Your Honor. The problem with that argument is it totally overlooks the last statement that he made, which is, I'm coming for you, which I don't think you could even argue about. The first statement is, you better watch your backs. You'll be watching your backs for the rest of your life. In the slang vernacular of Allen County, we all know that's not a threat to sue you. And as far as the taking legal actions, the problem with that argument is this Mr. Madden has no right to file a suit for slander because his father's been put in jail. He has no right to sue the Scottsville Police Department based upon what they have done in a case that doesn't involve him any more than I would or you would. So that's not that's not where this threat is. The threat is, and I think Chief Pearson handled it correctly in the sense of he knew he was young, he knew he was mad, he understood while he was mad. When it said, you're going to have to watch your backs for the rest of your life, Chief Pearson didn't go off half-cocked. He actually communicated with him, told him, you can't threaten us like that, especially in this day and age. And then he came right back and said, I'm coming for you. And that's when the charges were brought. And I think it strains credibility to believe these were anything other than threats designed to get the police off his father's back.
Thank you very much, Mr. Higginbooth. I do find that there is sufficient probable cause to believe that a felony has been committed and that Mr. Madden is the person who committed that felony. I believe applying the understanding of a reasonable person in this community that to say you must watch your back and I'm coming for you certainly imply a threat of violence. Therefore, I am making that finding that probable cause exists. This case will be bound to the grand jury. The next thing you hear about this, sir, will come from our grand jurors. They will either return a true bill indictment, a no true bill, or perhaps they will remand it to this court to be prosecuted as a misdemeanor. Those are all possible things. At this time, do you care to make a motion on bond?
Judge, please. Obviously, he can't make the bond as set. I've indicated or discussed with him what he thinks he might be able to make. He thinks he could probably make a $2,500 bond. My understanding is currently set $40,000 at 10%. We asked the court to modify it to $25,000 at 10%. It's still a considerable bond for someone in his situation.
Mr. Hagenbu?
Well, you've already lowered the bond. I think your original, if I remember this right, I think your original intent was to have each charge have its own $2,500 bond, which would be $40,000. And then when you cut that by 10%ing it down to $4,000, I think that's a very reasonable bond given the charges.
Is there any objection to a bail credit against that 10%?
Yes, Your Honor. I mean, he's threatened the police department. I don't know whether he's serious or not, but I don't want to find out the hard way.
All right. Well, I'm going to keep the bond the same. I do think that's reasonable to set it at $2,500 per each of the 16 counts of intimidating a participant in a legal process. Certainly 10%ing that is very generous. Mr. Madden, an additional provision, if you are to make that bond, is that you stay out of Allen County, Kentucky. All right,
and can we ask for another condition that he not further communicate?
Oh, yes, I already
law
had put
enforcement officers?
Yeah, no communication with our law enforcement officers and stay off social media, Mr. Madden. All right. Thank you. That'll conclude this matter. Okay. All right.
Judge, that's all I have.
Thank you, Mr. Hendricks. You may be excused. Good luck to you all. Exciting time.
Actually, Judge, I take that back. There was one more case at the DPA that's going to take this morning. That was Kelly Branham.
Yes, we've issued bench warrants for Ms. Branham because she failed to show. Sorry, Mr. Hendricks. That happens.
Be here anyway.
Thank you. All right. Ladies and gentlemen.